Hi, I'm Bev Lyman. I'm Chief Intellectual Property Counsel, and this is Dan McNerney, Technology Manager for Regenstrief. And although I'm a lawyer, and I'm going to be introducing two lawyers that are working with us from Faegre Baker Daniels in their Denver, Colorado office, feel free to pose questions, ask questions in non-legal jargon. We want it to be easy for you. We want you to understand the process because that's going to help us give you a better patent application, trademark application, copyright registration, whatever we have. So I'll let Dan take it over and introduce himself and our video-in guests from Faegre Baker Daniels, and we'll take questions. I'll stay afterwards, whatever makes it most comfortable for you to ensure your technology, your inventions, your creations are locked down, are protected for your sake and for Regenstrief's and Indiana University's sake.
Thanks. How are you? Hi, so as Bev mentioned, I'm Dan McNerney. I'm a technology manager at the ICO, so Innovation and Commercialization Office at IU. So I've worked with some of you already, but typically, we can interface with any IU affiliated faculty members on matters related to intellectual property. My background is in engineering, so some of the spaces, you guys are the experts, and I rely on you. But essentially, I act as a bridge between the faculty members and our legal team to help with the appropriate means of protecting your IP, and then we handle the commercialization as well, working with Chris. So I will stick around for after this talk. If anyone has more questions, I'll have some cards if you need to reach out to me after the fact. But I think we're just going to spin right to Bob O'Loughlin and Ryan Diebner at Faegre Baker Daniels. They are a law firm that has an office based in Indy. They are based out of Denver. Their Denver office, very relevant technical backgrounds to this audience here. So I thought that they'd be a great group of people to come in and sort of talk about the evolving landscape of software IP and appropriate steps that we can take to better protect that IP.
Thanks, Dan. So we're experiencing a technical difficulty in the morning at the moment because our presenters are not on the Zoom. So I didn't want Dan to sit here and wither in flames while we were trying to push this through. So we're texting them right now to get them jump back in there out of Denver. But I thought it might be a minute while I tap dance up here to just sort of frame out sort of maybe a few of the ways that. Excellent. I don't know if we have their PowerPoint on here or not. We may have it in a minute. So we're going to scramble just a little bit and appreciate that this is a live event and we're working through it. Bev's going to kind of lead through the presentation while we wait for them to get on. But why should you protect your IP and how might you protect it? I think it's probably going to kind of what we're going to try to go over a mile wide and inch deep. And if you want to get deeper in any of those layers, we'd be happy to do so with you. But you've probably all heard the idea of a trademark. That's what you see at the end of the Coca-Cola symbol, which means that if you try to use that Coca-Cola trademark without paying them for it, you're going to get sued. Copyright is similar to that. When something is owned by someone else and you try to use it, you have to defend that. You're going to get sued. The other two, a patent, which you probably already heard, you patent an invention and you can't reuse that technology or that patent anywhere, or you're going to get sued. The last one is really interesting, and that is trade secret. And so, Google hasn't patented anything. They hadn't trademarked anything except for Google. And there's no copyright on the Google search algorithms because they're hidden on a server. And if they told you what that algorithm was, they might have to kill you. And so there's sort of the four pathways that you might need to protect that. Why would we want to protect those inventions? Because we want to take the unique, novel innovations that come out of our ecosystem, protect them so we can commercialize them and make large amounts of massive impact with that, with great partnerships. Yep. Clicker right there. Yep.
Okay, well, I'll get started and we'll wait for them to join. And what we're going to talk about most of all today is software. And the questions are, Can you patent it? Can you copyright it? How do you protect software? How do you protect code? And what we're going to give you is some very practical advice, pragmatic and practical, what to do, and most important, what not to do, our respective roles. So from the legal side, our job is to get this through either the U.S. Copyright Office, if it's a copyright, or the U.S. Patent and Trademark Office if it's a patent or trademark, but we're going to talk just about patents today. Your job is to tell us what you've invented, what you've created, and we're going to ask you a bunch of esoteric questions that you may think, what the heck is going on here? But it's important that we do the dance between the patent examiner and you as the technical, scientific expert in this technology. So we're going to be your conduit as we progress through the process of patenting or registering your copyright. The technology is, in terms of a Venn diagram, has to meet all these criteria. It has to be new. It has to be not obvious. These are legal terms, though. So when you use email to say, oh, it would be obvious to do this, please don't do that, because it's a legal definition, and we're going to argue for all we have that it's not obvious, and we're going to give those patent examiners the reasons it's not obvious. So when you don't counter us, we can talk live, we can talk in person or on the phone, but be careful what you put in emails. It's much better to have a conversation about this in real time. What you want is enforceable intellectual property. In other words, you don't want intellectual property so narrow in scope that your competitor can make a quick change and get around it. So you want as broad a protection as is reasonably possible for what you have invented already and for what you're going to be inventing or creating. So think ahead. And when you think ahead, put yourself in your competitor's shoes, so to speak. What would your competitor do to get around this technology? And then tell us, and we'll make sure that's protected too, which is a good thing for you. And then definitive, as much as possible, we want to buckle down and define what it is you've invented in all the legalese that we have to use, but in terms of the scope of your invention. So partitioning it, putting it in a place and space, and then our job is to kind of interrogate you as the creator, as the inventor. What did you do? Why did you do it? How did you come up with this? What would be another way of doing this? What other systems can you use? How far can it go? Where can it be applied? Where can't it be applied? So you're going to hear some negatives in this conversation today, and that's a good thing because we want to define the scope both proactively, what it does, where it is, and then what it doesn't do. Where isn't it? Where wouldn't you be able to use it? Because that can be very valuable protection too. So tuck that in the back of your mind. The criteria for what is patented is changing. You don't need to hear our problems, but it's a slog through the patent office for some of this technology. But that's our problem. We'll handle it. Don't worry about it. We're going to ask you these questions as long as you answer us, but we'll be truthful with you. We're not going to hide anything from you. Some of it won't be patentable simply because it doesn't meet the, quote, eligibility guidelines, but a lot of it is, and that's where legal counsel can come in very handy. We can kind of massage it, work it up a channel that it might not ordinarily go. But we've got some eligible subject matter. Pretty much we can find something. Whether it's important to you is a question for you that we'll be asking you. What you want to do is, if you go through this pretty intuitively. So you've made some sort of an invention or creation or improvement over what's been done before. So good for you. You're the inventor. What our job is, if you go to number 2, our job is to phrase it precisely using the jargon that we need to use to get it patented or copyright registered. The background, where you came up with this, how you came up with this, and why it's an improvement, we're going to put that in your application. And then we're going to talk about both conventional, non-conventional ways of eliciting the functionality of this or the uses of this. So here are some very practical do's and don'ts. Don't document the history. Don't leave out the hows and the whys. So tell us everything, but we'll decide what to put in and what to leave out. Sometimes we need to just tuck things in the back of our mind too, and that'll be helpful. Do describe how the closest known art, or think of art as your competitor, sort of big picture. How does that function? And then describe any limitations and why they're important. I can do this, but I need to, and then fill in the end of the sentence. And the more you can get in the flow of this, the easier our job is going to be helping you. So think logically, think intuitively, but think creatively. You can think broadly. You can say, you know, Bev, this will never work, but it might work. And then we'll decide how we can phrase that. There are ways and there are ways. You'd be surprised. So some very important do's and don'ts here. Don't only describe inputs and outputs, but do describe inputs in detail, outputs in detail, and how your invention operates on the inputs to produce the outputs. In other words, close the loop, tell the full story. Here's what I'm going to do, here's how I did it, here's why it works, and then here's the result.
Go ahead.
You might be on. Hey, Beth, can you hear us?
Yeah, we can hear you, but not very well.
Okay, we apologize. So we actually tried to work this out, and we did get it working about an hour prior to this. But we could hear you, but you couldn't hear us when we were trying to connect.
Okay, so you'll pick up after this. You see what slide I'm on?
Yes, and thank you very much for thank you very much for stepping in. So again, our apologies. So I'm Ryan Diebner, this is Bob O'Loughlin. So yeah, related to the software inventions, you know, there's been a lot of confusion lately since the Supreme Court came out a handful of years ago about whether or not you can patent software inventions. You can under certain circumstances. And so that's kind of what we wanted to kind of go through here. Basically, you know, I mean, so in order to patent a software invention, you generally have to include a decent amount of detail about how the algorithm works. And kind of these are some different practice pointers that you can follow while you're completing your invention disclosure. And using this information, then we can create a more robust patent application so that in the future, if we do come up against a subject matter eligibility rejection, that we can go ahead and amend the claims or argue what's based on the specification as opposed to relying on attorney argument after the fact. So on practice pointer number 2, so this is probably one of the most important practice pointers. So it's describing how the invention works. So generally, prior to the Supreme Court case, you know, a lot of times it would just be like, okay, well, this is how, these are the inputs that are received, and this is what the output is generated based on this algorithm. And here, you know, what we want to do is actually include a lot more detail on how it actually gets from the inputs to the output. So, so kind of as you can see, don't just describe the inputs and outputs. That used to be fine, kind of under the old regime, but now you need to include a little bit more detail. So, it's basically you want to create a roadmap of how you go from the inputs to the outputs. And then as we get into here, we can actually kind of talk about how that's actually done.
Yeah, and also describe the inputs themselves and the outputs when you're talking to your patent attorneys or preparing your invention disclosure forms, because sometimes or oftentimes the invention that you've come up with is putting a certain type of input into a black box that's already in existence, and there's nothing new about the black box that it's going into. And you're getting something out that maybe you're doing something different with, or that's coming out a different way because of the way you put the inputs in, or the way you configured the inputs. So a lot of times there can be novelty and patentability around the way you structure the inputs, the way you feed them into one or more of these black boxes, the way they work together as they're going in, and similarly the way they work together as they're coming out.
And to that point, it's, one of the main type of things, and hopefully it will come across by these practice pointers, there has to be a practical application to it. So we, and basically what they're looking for is kind of this, how is it tied to a computer and how is it improving either the functioning of the computer or, rendering better results or things like that. And so that's kind of what we're talking about here. So how is an improvement to the state of the art? So it needs to have a practical application, and it needs to kind of be built upon the state of the art, but what is it actually improving over the state of the art? So oftentimes prior to the Supreme Court case, all you could say was, well, it's an improvement. Speaking with multiple examiners, they said, we would withdraw this 101 rejection, but we need to know how much of an improvement or how it improves on the art. So including details to that, to why it's actually an improvement, how it improves it, and why is it better than the state of the art. So is it less computing? Less computing power is necessary. Is the architecture simpler? Different things like that on how it actually improves the state of the art, as opposed to under the old regime, you could basically say, well, just do some hand waving and say, well, it's an improvement. It didn't really. There almost needs to be some kind of evidence as to what the improvement is and how it improves it.
And I'm pointing to the words how and why here. So how it works and why it's better. Okay, we're on best practice number 4.
Yep, and again, so this is the point that we were discussing before. So the practical application of the invention. So, and this all relates to whether or not it goes hand in hand with the previous one, whether or not it's an improvement. So how is this actually going to render useful results in the real world? So, oftentimes there's a lot of data analytics going on, and, for example, so if you're taking all these inputs, you're generating this output, and the output is some kind of an indicator of whether or not somebody may be experiencing, a heart condition, and you're actually determining that prior to what previous embodiments could determine. So you're catching the heart condition sooner rather than later, and which is a very practical application in the field of trying to take care of a patient. So I mean, that's kind of one of the main aspects of, well, how is this actually going to be applied in the real world? Is it for better patient care? Okay, that's great. Well, what's the better patient care? How is it render that better patient care? So with that, you want to include that practical application. You also want to say, okay, well, how is this actually embodied in the real world? Okay, so you have this computer architecture, you have these processes, it interacts with this kind of data that's being sent via these sensors. So how is the physical, how is it physically realizable in the world? So you're taking the sensor data, you're manipulating the sensor data, and you're determining an output based on that.
Yeah, I think this is a caution. If you've been working with patents for years, you may remember a time when you would invent something like an algorithm for taking in some physiological data and outputting a predictor of some state of a patient. And a temptation and a reality years ago, and I mean 10 years ago or more, was to patent the idea of taking information, whatever it was, into that algorithm and outputting a predictor of something. And I think that the message here is we no longer have confidence in an ability to patent that broadly and generally. Now, the Patent Office and the courts really want to see what is the invention that you came up with to better the world. You know, what is it going to be used for, as opposed to, you know, how broad can you make it and how many people can you block from using similar ideas.
And then for best practice 5, here we get into the real nuts and bolts of this, what to do, and we're going to give you some examples. So in the 7 minutes we have left, go ahead, Bob and Ryan.
Yeah, so this one, and this is kind of goes to the how. So how are you going from inputs to outputs? What decisions are you making? And different things like that. So one of the things, you know, it's nice to provide at least one flow diagram. So a flow of basically, you know, the inputs, you know, what inputs are being into the system, what decisions are being made along the line, you know, along the matrix, the algorithm, and then here's how it's generating the outputs, and along with different decisions along the way. So if you're receiving, you know, a parameter that's above or below a threshold, and based on those different, you know, whether it's above or below, you have a different decision to be made. Include that in the flow diagram, and we're going to show you a couple of examples. And these are just other kind of practice pointers. So, you know, don't only include one drawing per page. Detailed flow diagrams, editable drawings are nice just because we can include those, or, you know, range them in the patent application or adjust them to the needs of what we want to disclose.
Right. And if you're generating design specifications as you're working on your invention, those are helpful to us as well. And you know, please be sure to share those, and then also share with us what, if any, aspects of it you want to remain secret. But again, the more information, the better.
So here's a flow diagram that's not good, and they'll tell you why it's not good.
Right. So this just very generally describes an idea. Of receiving a set of IP addresses, looking at a previously captured set of IP addresses, determining the number of IP addresses that are showing up again, and then determining an estimated swarm size. And it doesn't matter what a swarm is in this context, but it's a concept about the way IP addresses are sort of reused, and then determining the length of a time interval to wait to resample IP addresses. This is a method of capturing fraud on the internet. Again, very simple. This really amounts to looking at what we have, looking at what we've seen before, and determining how long we should wait until we look again. And it makes for a very challenging patentability story.
Yeah, and so, you know, I mean, each one of these steps is probably, so what do you know, what is being looked for in this determinate estimated swarm size? Like why, you know, like what estimated swarm size are you looking for? Is it above or below a threshold? And different things like that. Is there, how are you, you know, and again, like the length of time interval, like what types of length of time intervals are you looking for? How is that going to make a determination? How is that going to affect the algorithm? How, you know, how are you going to act on those two differently?
So here's a better flow diagram.
Yeah, and so as an example, the flow diagram you see here basically captures the last two steps of the previous flow diagram. And it doesn't matter what all these functions mean, but so 308 and 310 look like that in reality. And the message here is this is what we would like to see. We can abstract something like this out into a more general conceptual diagram if we need to or want to or think that you know, there's a good business reason to do so. But if we don't have detail at this level, it can be very difficult for us to produce a robust patent application.
So now we're going to talk about claims, because the claims are the only thing that matter in terms of protecting your invention. Everything else supports every word in your claim. So here's one claim that doesn't have enough detail. Go ahead, Bob and Ryan.
Yep, and so this is the main thrust of these practice pointers, including the flow diagrams, are basically so that we can draft claims in enough detail that they can overcome any subject matter eligibility rejections. So,
and prior art.
And prior art rejections. So I mean, if the examiner comes back with a rejection for subject matter eligibility, saying this is an abstract idea, what we can do is look at the specification and then go into those flow diagrams and point to specific aspects about how it works. So here, you know, and just including enough detail. So basically, when it gets down to the claim level, that we have the ability to go back and modify the claims in a sufficient manner so that we can overcome any of those subject matter eligibility rejections. So this is kind of
we can't add anything. We've got to deal with what we file. So here's a better claim, and you'll see it's a lot wordier.
Right. Yeah. And so going to so the previous claim example was probably, that's about the amount of detail that we could have included on that first bad example of the flow diagram. Here, you're going through and, you know, based on the additional detail in the flow diagram, we can add additional details to the claims because everything needs to have basis in the specification, in the written description, in the diagrams. And we can go through and basically further amend the claims to bring in that detail that we necessarily need to, in some instances, overcome these rejections. So that's the extra kind of kick that we need to for software inventions that you may not be otherwise need for, you know, other types of inventions, mechanical, electrical, that, you know, are peculiar to software inventions. It's just, it comes down to, we need to include sufficient detail so that we can overcome any abstract idea rejections.
So we're glad to take questions now, later, individually, collectively, come back. Go ahead.
Can you just address two things real quick? When is it too early to come to talk to the team, and who pays?
Dan, why don't you take these questions? As the technology manager, he's used to these. Earlier, the better.
Applications, you can work out there. Always best of our ability to work on that timeline. So if you have a presentation conference coming up, you will get something on file and then revisit it. You never want to hold on.
Who pays?
As far as I can tell, we are planning as I have a discussion going on at a higher level. We do an evaluation from whether those markets or it is time eligible. IU will file a provisional and that we will evaluate it. We're not going to, unless there is a market or a someone to pick up those costs, we're not going to file. So we'll likely look at those applications.
Okay.
IU will be
So IU will pay. And then we'll share this PowerPoint with you if you need it, or Todd or Chris have copies, and glad to walk you through anything you need.